Hello and welcome to Prototype and See, a brand new podcast for designers, engineers and innovators all about the product development journey. My name's James Murphy, co-founder of HLH, one of the world's leading manufacturers of prototypes and low-volume production parts. I've been in this industry for nearly 20 years, but I feel there's still a great deal about our customers that I don't yet understand. So, in Prototype and See, I'm going to be sitting down with some of the world's most innovative companies, talking to designers and engineers, all about the successes and failures, the ups and downs of bringing new products to market. With me today, I have one of our most experienced project managers, Archibald J.
Hi.
And we're also talking with a little bit different today. So, we have Ben Chapman from Carpmaels Ransford, the one of Europe's leading patent law firms. Hello, Ben. How are you?
Thanks for having me. I'm great. Thank you.
Okay. Thanks for coming on. Please, I guess you can just start by telling us a bit about you, your background, and about the company and what you guys are up to.
Yeah, so I work at Carpmaels Ransford. We're a patent law firm based in London, here in the UK. It's one of the oldest firms in the industry. We've been going for hundreds of years, and we're steeped in history. But we are a full-service IP firm. So we deal with patents, and we help inventors and companies get their patents drafted, filed and granted. That's a lot of our work, but also we deal with people's trademarks. We help them with copyright. We help them with designs. We also have solicitors, so we can help people resolve disputes that arise out of IP. So basically, if it's related to intellectual property, our firm helps. I'm a patent attorney who works in our engineering and tech group. So I kind of straddle all kinds of technology, everything from mechanical cases, software cases, and we've got quite a large medical technology focus within our practice group as well.
Okay, and is it mainly larger companies that you're doing this for, or you also work with kind of small startups?
A bit of both. So it's a really nice job being a patent attorney at a private practice firm, because you get to work with all different types of corporations and even individual inventors. So I've got some clients who are, effectively guy in a shed with an idea, and others of our clients are huge multinational corporations that are very sophisticated, and they have their own in-house IP team, and we sort of work with them, say, to do the European side of their work if they're based in the US, or with special niche issues that they might not have as much experience with. So it's the full range of types of clients.
Okay, and say I've got an idea for a new product. I feel as though it's quite innovative. How do I know I need a patent?
Well, that is a very good question. And probably before we start with do you need one is just focusing on what a patent is, because I think it's hard to understand whether you should get a patent unless you think about what it is and where the value is.
Okay.
So what a patent really is basically it's a right that's granted to you by some government organization, and it's what we call a monopoly right. And what that means is you have a certain right over a certain, what we would call scope, sort of a definition of an invention, and you can prevent other people from practicing that invention.
Okay, and how, just to jump in, how different would somebody else's invention need to be in order for them to then go and kind of reapply for a different patent? That's
a really good question. So what a patent contains is it contains like a big description of how to put your invention into practice, and then at the end of the patent there's a section called the claims. So you've probably never read a patent, because
no.
Why would you? They are not like bedtime. Well, actually they're excellent at getting you off to sleep. But the two different sections of the patent application and the patent after it's granted do different jobs. There's a description that tells you everything you need to know to actually make the invention happen, to put it into practice. Like if it's a new device, everything you need to know about that, how to make that device, or a new process, everything about that process. At the back, there's what's called the claims, and that defines with words what the invention is. So let's say you've come up with a new mechanical device, and it's got a new kind of interlock that has a certain number of different parts, and they connect together in a certain way, and there's a certain sequence in which they operate. You would say, you'd write out in words features, these components, and they operate in this way. and we think that this is a new and inventive way of creating this interlock.
Okay.
So that's the claims.
Uh-huh.
They're important because those claims are what define your monopoly.
Right.
So if you see someone else doing something that falls within that definition that you've done there,
Okay.
then you can take action against them after your patent's granted.
Okay.
But equally, those claims are what are examined. So
Yeah.
you don't just get given a patent. You write a patent application, which has this description, has this claims, then you send it off to a patent office.
Okay.
And then a patent examiner picks that up. They read the descriptions, they understand the invention, they look at the claims, and they say, okay, what you've defined there in those claims, is that new? That's step one. And is it inventive? That's step two. So new, that's pretty straightforward. Is there anything out there that I can find that falls within the scope of these claims? You know,
Yeah.
if, going back to our example, okay, I've got a document over here that has these 3 components you've said, and they work in the way that you've said that they work. Okay, what you've written down there, that's not new over this document. And the examiner will write and tell you that. And then the next question is, well, it might be new. No one might have thought to do it in that way or disclosed doing it that way before. But is it obvious or not?
Yeah.
And that's kind of the slightly more subtle step.
Okay.
And it's a question of whether someone who took everything that existed in the world before and starting from all the relevant bits of technology could look at that and without applying any kind of inventive thought arrive at what you've claimed. So if what you've claimed is it's new, but it's basically just a workshop modification of what came before.
Right.
Or if you were to put together 2 different ways of doing things, 2 different documents,
Yeah.
and put them together, you would get the thing that you've written in your claims.
yeah,
Then the examiner will come back and they'll say, well, it might be new, but it's
not
obvious.
inventive, innit?
Exactly.
Right. Okay,
It's not inventive.
Okay. And then who writes those? So who prepares that document? Who prepares the claim? Would that be the inventor, or would that be you guys?
In an ideal world, it would be a patent attorney. And obviously I would say that because I'm a patent attorney. But the reason for that is you as an inventor and as a designer will be absolutely on top of the technology, and you'll have a really, you will know what's come before. Probably you might be working off some, scoping work that you've done on the market out there. You might know what's come before. You'll also have worked through that product, and you'll have met some technical challenges probably to arrive at the design you've got to, and you'll be all over that. What a patent attorney can do is look at that and say, okay, this is where you've got to. This is the final product, and this is how it works. But what's the real big idea here?
Yeah.
What's the inventive idea, and how can we define that invention in a broad way? So we're not just talking about maybe, there's a very narrow sense. You've got certain components interact in a different way.
Yeah.
But a patent attorney might be able to have a conversation with a product designer and say, okay, well, I see that the reason that you've put these components together in this way is you're solving this particular problem. And there's a slightly bigger concept, and we can write a claim
the broader the kind of idea, the better protection it provides, I guess.
Yeah, you hit the nail on the head there, James. That's the name of the game, is the claims. If they're nice and broad, that's great, because that covers not only your product, but lots of different modifications, right?
Yeah.
So you won't get someone coming in and entering the market with something that's similar, maybe not exactly the same as what you've done, but similar, but still doesn't fit within the scope of the claims. So you want it nice and broad.
Yeah.
But also, broad claims mean you might have captured some stuff that has come before, or it might be so broad that you've not really come up with anything inventive at sort of that level of generality.
Yeah.
So that's where a patent attorney comes in, both in drafting the application, because they'll try and get those claims the right level of generality, but also that's part of the patent examination process, which is what comes after you've written the patent application.
Okay. So going back to the original question, like, how do I know if I need a patent or not?
That's a key question.
Yeah.
So just going back to what rights do a patent give you, that what that patent can do is that claim scope, that definition of your invention, you can stop other people practicing that invention. So if someone comes onto the market and their product falls within that definition, then you can take action against them in the courts and say, please stop, or get some monetary damage.
So essentially, to stifle competition, would you say?
Stifle is maybe too strong a word. To protect your innovations is probably the slightly more on-message way that I'd put that. But basically, that's the value that can give you, right? That monopoly is going to be able to stop someone falling within the scope of those claims.
Okay.
Now, whether or not you should get a patent is how much value does that actually have to you and your business, right? So if you've got a product and you feel like there is some particular technical innovation here, and that innovation is giving your product a commercial advantage, you should do what you can to protect people, to prevent people from coming in and reproducing that technical innovation, and thereby, depriving you of that commercial advantage.
Yeah.
So if there's some technical innovation that's giving you some commercial advantage, then I think you should be protecting that. That's a good reason to do it. Another thing to think about is not just protecting your own product, but if you have maybe a very broad claim, or maybe you've done some kind of process where you've identified lots of different approaches to solving this problem, you might end up filing patent applications to routes that you didn't take.
Okay.
And the reason you might do that is, you don't know what Gen 2, Gen 3, Gen 4 of your product is like. And it might turn out that, oh no, actually that idea that we had but we didn't pursue initially was actually worthwhile. And you want to have the protection in place over that. But also, new entrants into the market, they might say, oh, they've got this product works this way. Maybe we can make a product that works that way. If you've closed off some of those avenues with your own patent portfolio, then again, you can maintain that commercial advantage.
Okay.
Or equally, those patent applications might have some value because you could sell them on.
Yeah.
You could license the technology, and basically people would have to pay you to operate under that.
Yeah.
And sorry.
No, I was going to say, does it encourage innovation then, would you say, these patents? Would you?
Yeah,
would you say?
I think so.
Think outside the box.
Because
a bit?
there is an argument, and especially like say the fashion industry. I think they don't have patents. I think. And a lot of people argue that means it's much more kind of creative and innovative than a lot of other industries, and they argue that patents actually, coming back to the word that he used, stifle innovation in many ways. Do you agree with that? Or?
I don't think I would. And so I think the reason for that is, well, the way that it's sometimes described as there's the patent bargain, right?
Yeah.
You are filing an application, you're going to get granted this scope of protection, this monopoly that we were talking about from the claims. But there's the other half of that patent application. There's that description. You've got to put everything in detail of how to put that invention into practice, and that is contributing to quite a huge technical wealth of information that's out there. And when, let's say, there might be lots of details in there and the claims end up being narrowly focused on one specific aspect, but all of that other information has been contributed then into the public domain.
And people can take that, use that.
Exactly. It's a starting off point for other people to develop their own ideas. And when the patent term expires, because you don't get granted a patent forever, basically it expires 20 years after you originally filed the application.
It's always 20 years irrespective of...
Yeah. So basically... the clock starts ticking when you file the patent application, and 20 years later, by and large, pretty much in every country, that's the term of the patent. The patent will expire. Now, there's a couple of months, there's a couple of years that it will take to get your patent application to the state where it's granted, and then you can then enforce
Takes as long as that.
And maybe we can circle back to timelines because I know that's something that people get stuck on. But even if it's taken you 5 years to get the patent granted, takes you 10 years to get the patent granted, or even 19 years and 360 days to get the patent granted, that term expires at year 20.
Okay, so you're protected throughout the application process.
Yes, in theory, yes, but you can only enforce a patent once it's been granted.
Right, okay.
So your patent might be pending, and then anything that people do that would fall within the scope of a granted patent would still infringe that patent, and you can seek damages back for things that have occurred before the patent was even granted, so long as it fell within the scope of the claim.
Okay, so you can kind of backdate your...
Exactly, you can backdate your claim, but you wouldn't be able to take any action to stop anyone doing anything until your patent is granted.
Right, okay.
And just tangentially, this is an important point, particularly for people in the UK, where it's against the law in the UK to threaten people with patent infringement if you don't have a granted patent that covers them.
Okay.
So the UK is quite unique in that respect because we have what are called threats provisions. So don't go waving your patent applications around threatening people because you'll get in trouble.
Okay. Yeah. So the other objection that I've kind of encountered in the past to a patent is when Elon Musk started SpaceX.
Mm-hmm.
He basically said he wasn't going to bother with any patents because if he did, he was basically just providing a recipe book for his competitors to essentially just take what he'd been doing, tweak it a little bit, and go do something similar. Yeah. So what would you say to that? Like,
I think there is some truth to that, and I think you have to be mindful about what value can you get out of that scope of protection.
Yeah.
If, and I don't know how true this really is, but if it was the case that a competitor would be able to come along, take that recipe book and start providing a competing service or product, with some small modifications and fall outside the scope, then that's not a very valuable patent.
Yeah.
But probably something's gone wrong along the way in terms of drafting that patent or prosecuting that patent or the decision to file the patent in the first place. And I think you always have to be mindful of what value are you going to get out of that patent that's been granted versus the cost of putting all the information out there and the cost of actually prosecuting the patent itself. So to flip this on its head, say, all very well for Elon Musk, right? If he puts the recipe book out there, then people get the recipe book. But if you're putting a product into the market that your competitor gets hold of, tears down, can see how it works, can turn around their own version, there is no way of you keeping your recipe book secret, right? And if there's some technical innovation that's gone into that product, there's nothing that you can do if you've not got intellectual property that covers it.
You think you'd be better off protecting the IP than trying to keep it secret?
Yes, depending on the situation, right? There's lots of situations where maybe...
Well, can you think of an example where it might make more sense to try and keep it secret rather than...
Absolutely. So I think we talk about intellectual property and sometimes people straight away go thinking about patents. But that's not all your intellectual property, right? There's all your ways of doing business, all of your processes, and some of those are going to be patentable innovations because they're kind of related to industry. Some of those are going to be on the border of what we'd say are patentable and not patentable. And maybe those, all you'd be doing is putting all the information out there and the examiner might come back and say, this isn't something that you can get a patent for because this is really it's a method of doing business, or this is just purely mathematical. And that situation,
you're basically telling everyone how you go about doing things, but you're not getting
anything to show for it. Exactly. And then the other situation is maybe where you truly can keep something secret. And it's how much confidence do you have in that? But if there is, your innovation is maybe a process of manufacturing something. Now, you can definitely patent processes of manufacture, but you might think, well, I think I can keep the secret. And not only that, I think I can keep the secret for 20, 30, 40 years. The classic thing is the recipe for Coke, right? That's kept under lock and key, and the people who know it in their head aren't allowed to get on the same flight and all this kind of ridiculous stuff. And that's never been put out there in the public domain, and they've kept really tight control of it. And if you think that you've got the new Coke and you can keep a tight control on the recipe, sure, great. But reality rarely meets expectations when it comes to that. And I think particularly in a situation where you're putting products out into the marketplace, it's quite difficult to actually keep those innovations truly secret.
Okay. Well, what about like working in different countries? So like, how easy is it for, say, a company in another country to look at UK patents and then recreate the products overseas?
Great. That's another really great question, James. So an important thing to understand about patents is they're granted for particular countries or particular regions at a time. So if you file a patent application at the UK Intellectual Property Office, what they can grant is a patent that covers the United Kingdom. That won't help you if someone sets up shop in Germany and sells only into the German market, or sells all around the world but never sells into the UK. You can't take any action against them because your monopoly has only been granted in respect to the UK. The way that the patent application system works is you can file that first patent application, and then up to a year after, you can file follow-on applications that, and this is a bit of legalese, claim priority back to the first application. What that means is it's basically benefits from that earlier filing date. So when the
Okay.
examiner looks for prior art, it's going to look at that first date, but you've had a year to decide, okay, is this worthwhile? Is this really worthwhile? Do I want to get more protection in other countries? And there are
Yeah.
ways that you can either file specific applications in specific countries, or you can file what we call an international patent application that basically really actually just defers the decision for another 18 months about the specific countries that you want to go into.
Okay.
But there are ways to basically take that initial patent application and seek protection in other countries.
But you have to do it in each individual country jurisdiction.
Yeah,
That sounds like it could get very expensive.
It can get very
very
expensive
quickly.
very quickly, and that's why you have to think about the proper value proposition that those additional patent applications are going to give you.
Yeah.
So there's no, if you're based in the UK, you're only ever going to deal with UK customers. Maybe you only need a UK patent.
Yeah.
If
looking
you
to sell overseas,
exactly
then you
looking
might
to sell
need to think-
overseas, or that everyone's going to be producing overseas, say,
Yeah.
if you have a good sense of where your competitors' manufacturing bases would be, where the key markets are, these are the places that you should be thinking about when you're determining what we call your
How
filing
does Europe
strategy.
work? Is Europe like a single entity, or are they individual countries?
Europe is in a state of flux. So there is the European Patent Office that's actually nothing to do with the EU,
Right.
and the UK is part of, as are countries such as Turkey, Norway, Switzerland, other non-EU countries. And what that will do is it's a centralised place where that patent office will basically look at a patent application, decide whether or not it's patentable or not, and grant you a patent. And after that, you can choose the specific countries in which that patent will have effect, and there'll be different costs associated with that.
Okay. Yeah.
And, if you're maybe a medical device company and you know that this is going to be used in every single operating theatre all around the world, you'd pick every single country that you could. If you're basically a consumer goods and you know that there's 2 or 3 key markets in Europe, you might only pick 2 or 3 countries. That's actually changing. So there's a new system called the unitary patent that started this summer, where you can get a single patent that covers a load of countries at once.
Right.
This is getting way too into the weeds,
Okay.
probably.
Okay.
But basically that means going forward, there will probably be a cost saving to getting broader coverage across Europe, which I think is good.
How come that wasn't a thing before? How come that's only recently become a thing?
Well, I think it comes down to try and get 28 countries to agree on anything is always quite difficult. And then we had Brexit happen halfway through. So I've been in the industry for 10 years now. I've been a patent attorney, and I remember coming to my interview and thinking I was very clever for thinking, I'll find out what's going on in patent law. Oh, the UPC, the Unified Patent Court, and this system, that's all very exciting. And the people I was interviewing who were interviewing me then were like, yeah, they've been talking about that the last decade. It's never going to happen. And it's been 10 years since then. It has finally happened. But it's just a case of getting countries to agree on something, I suppose.
Okay. And you've mentioned that there are other options available to you to protect your product. So you said a patent, keeping things secret. Are there any other things out there that can help people?
Yeah, that's a really good question. I think there's, as you might be aware, there's patents are there to protect inventions that are sort of how things work or how things are made or processes. If you want to protect how something looks and how something appears, that's not what a patent is there for. Now, copyright will play a part of that, and what we call, like in the UK, unregistered design rights will play a part of that. But a really strong, powerful tool is called the registered design, and you can have design registrations in the UK, design registrations that cover all of the EU at once, and all different countries have their own kind of specific versions of this. But what essentially that is you file some drawings with an intellectual property office that show how your product looks, and then anyone else who comes into the market with a product that looks the same or pretty much the same as that, you'll be able to take action against them. So particularly if you're a consumer-facing company and you're looking to get some brand recognition and really get people attached to your product, you really want to be able to protect how that product looks and prevent people coming in with copycat versions. And the great thing about registered designs is we were talking about that examination procedure where a patent examiner will write back to you. You don't have that in Europe or the UK for registered designs. You just file the drawings, and unless there's something formally wrong, the drawings don't make sense, then it'll be granted straight away.
Okay.
And it's relatively cheap.
Right.
So just to do comparative costs here, filing a patent application getting to the stage of filing the application and working with a patent attorney to draft the application can often be close to £10,000, often much more than that.
Okay.
And then actually prosecuting a patent through to grant is often, tens of thousands of pounds again, and that multiplies depending on the amount of jurisdictions.
Beyond a lot of very small companies, then.
Sorry.
Beyond a lot of very small companies, that kind of.
That really does start to rack up, and again, that's why I keep emphasising you just got to make sure that's valuable. That value proposition works. But registered designs, that's kind of completely different because they cost a couple of £100 to file and get registered. Right. So that's really cheap to apply for.
Is that something that you guys can help people with as well? Yeah. Okay.
Yeah. So we have a big registered design practice as part of Carpmaels Ransford, as do lots of other.
But surely, I mean, for a product, say like some headphones, like they all look pretty much the same. So how do you do it?
Great. Okay, so that's a really good question. So we were talking about the scope of protection of a patent is you've written those claims, which are a definition at the back in words. There's a scope of protection for registered design, which is defined by the drawings that you file.
Right.
And if you ever come to enforce this in the court, the question will be, what makes that sort of unique compared to anything else in the market? And that's really what it's protecting. And the how close something has to be to it in terms of similarity in appearance to get captured by the scope of those drawings depends on how different everything looks in that field. So, let's say with a pair of headphones, they all look pretty much the same, but there are certain features on them that make that unique.
Yeah.
That's really the main thing that's going to be protected. And in fact, what you can do is you can use your design drawings to what we would say disclaim some parts of it. So if you know that all of them, what you really care about is how the parts that the ear covers actually look. So headband, you don't really care. That's not going to be particularly unique. And you don't want to be in a situation where someone has some set of headphones that looks exactly the same apart from a different headband. And therefore they don't fall within the scope of your drawings. What you can do is you can disclaim those parts that you're not as interested in.
Bothered about, right.
So you can do them in dotted lines is normally the practice of how it's done.
Okay.
So you can be careful in how you define that scope of protection when you do the drawings.
Right.
Again, that's where I think a good...
Working with you guys would help.
Exactly.
The same case applies to patents, right? Where you can choose certain features of not the whole product, but just certain parts where you think these are key.
So I guess switching back to patents for a moment, I think you're totally right, Archibald. There's different bits of a product normally that might give rise to different patentable inventions. You might have a single product that has dozens of patents protecting it. It might have lots of different features, all of which are doing different things and are invented for their own different reasons. And one of the things that we do with companies is sort of a process that we like to call innovation capture, or you might hear it called like invention harvesting or invention identification, where we'll try and work with a team as they're doing the product development.
Right.
And we'll kind of have conversations with them along the way.
Okay, so you get involved very, very early on then?
Ideally, yes. I mean, we think that's the best way to get your IP strategy sorted, is if you have those early conversations between the product designers or the tech team and patent attorneys. What a patent attorney will be able to do is sort of have that conversation and say, okay, well, why have you made that decision? Was that the only way that you could have done this? Or have you done some very inventive thought process to get here? And in doing so, you can help identify where those innovations have taken place. It might be that, you don't file patent applications to all of those, but if you do it in a systematic way, you can at least identify where you've made those real improvements and innovations. And that's good for your own, I think, as a business. That's good for your own internal housekeeping. Because you understand, okay, what are the USPs to this product? Where have we got to? But if you do it in a systematic way, then you can look at those as those innovations have happened and say, okay, well, which of these, if we got a patent to this, would that actually help us commercially? Is this a technology that if we close off other people being able to provide this, will this provide us some real commercial advantage? Because that's where you can really get some value out of it. And if you get patent attorneys involved at an early stage, then you can hopefully identify those key cases, and you won't just be filing patent applications willy-nilly or just filing patent
not
applications.
At 10 grand each.
Well, no, definitely. I mean, we'd all like to be in a situation where we could do it willy-nilly, right? But no, you can hopefully focus on what is going to really give you the best commercial advantage out of your patent portfolio. Yeah. And also, if you do this sort of process, you can track that through as the product develops. And it might be that, okay, you've started that patent application process, but you've decided you're not going that route anymore. Okay. And you can close down those patent applications and save that money and invest it somewhere else in your IP portfolio.
Okay. You say the earlier you start this process, the better the chance it is that, you get this patent approved, would you say?
I don't think it necessarily improves your chances of getting the patent granted. What I think it does do is it means that the patent that is granted is more likely to be helpful to you as a business. Right, if your patent attorney kind of understands what is this product really trying to do, what's the journey that the inventors have taken to get here, they're going to be able to write you a better patent application, and they're going to be able to work through the examination process and the grant process to make sure that the patent that you end up with out the other end is the best scope for your business. And my personal feeling is this is what a patent attorney, this is the conversation that the patent attorney should be having with you. And when you're working with a patent attorney, they should be asking you, okay, well, what's the aim for this patent? Are you just trying to get a bit of paper because you would like to have a patent and be able to put a patent number on the box, which is absolutely fine, right? And there's plenty of people who want the cachet and want to be able to market this as this is our own patented invention. That's great. But let your patent attorney know that, because they can go for a very narrow claim. It might be easier to get it granted. It might be quicker,
cheaper.
Exactly. But let your patent attorney know that. Whereas if it's like, well, we want to make sure we're protecting this key bit of the technology, or we know that this competitor's coming to the market and we think their device is going to be like this. Tell your patent attorney that, because that's great information for them to know, because without that commercial context, you're not going to get a patent that gives you the value that you need.
One other thing that we come up, people send to us like all the time is like a non-disclosure agreement. Like, how effective are they? Like, how useful are they?
They are. So I guess the stepping back a second is why are people sending you those NDAs, right? Yeah. And what that comes down to is we were talking about the requirements to get a patent. It's got to be new and it's got to be inventive. So new, it's got to be new over everything that's been made available in any means at all. So this isn't just you've published it, doesn't just mean it's on the website. All those things count. But have you presented it at a conference? Have you gone to like an angel investor event, one of these beauty pageants where lots of people are showing off products and you've displayed it there? That would destroy the novelty. That would make it considered not new. Have you talked to Jeff down the pub about it? In theory, it'd be difficult to prove it, but that is a disclosure of your invention. So what a non-disclosure agreement is there for is to say that what I'm telling you is confidential and should be treated as confidential, and therefore it's not a public disclosure.
So that then means that you're able to at a later date maybe file a patent for that particular
because it wouldn't have been publicly disclosed.
That makes sense.
The caveat with that is a non-disclosure agreement, I mean, it's an agreement with another party. So if you were to have a non-disclosure agreement in place with someone, maybe say an investor or someone who ends up being a competitor, and you tell them about this product, and then they go on and they sort of release this information themselves, save for a few circumstances, generally that will be prior art against your patent if you go to file it later on. You'd be able to take action against them for breaching the terms of your agreement.
But only once you've had your contract patent.
Well, no, this is the issue. You might not even be able to get the patent granted. So if the person that you've agreed with has gone and put it out there, you can take action against them under the terms of the non-disclosure agreement because they breached the terms of the contract.
But you might not be able to.
But you might not be able to get the patent. So as with all these things, it's a question of trust. As long as the party that you're dealing with is acting sensibly and you trust them to kind of act in a actual manner, and it's very rare really that this kind of should become an issue, but it's just something to keep in mind. Who are you talking to under the sort of scope of this non-disclosure agreement, and
Can you trust them?
can you trust them?
Yeah. Okay.
But that's the foundation of any kind of commercial agreement you're having with someone. You've got to have a degree of trust to know that they're going to honour their side, right?
Yeah, you guys work with lots of different industries. You said lots of medical, engineering. So, like, what kinds of things are people doing in the UK? Like, what are some of the most interesting patents that you've seen recently?
I think
can you talk about them?
Yeah.
Okay.
Yeah. Well, the first thing I have to caveat this with is obviously anything that I've seen too recently, we wouldn't have filed patent applications to, and I would not be doing my clients a great service to start blathering about it on a podcast.
True. Fair enough. Yeah.
But no, it's one thing. I mean, without just getting on to talk about me now, but one thing I absolutely love about my job as a patent attorney is the breadth of stuff that you see. One of the earliest patent applications I wrote, which was years ago now, as a trainee, was basically about 3 pieces of wood joined together.
Okay.
And it was just very clever bits of wood.
There
wasn't anything like groundbreaking. It wasn't the most amazing technology. It wasn't hard to do, but it was just a neat, clever idea, and then that was subject for a patent application.
Okay.
If you
did it get approved?
That one didn't, but for commercial reasons, they dropped it because they decided it didn't actually. It wasn't involved with it. Yeah, it didn't make sense to continue with that patent application. So that's an example of great little idea, shame, but commercially didn't make sense to keep spending money on a patent application. The other things that we sort of work on, we have a lot of clients in the medical technology space. So this can be anywhere from like the dental fields. We have clients in kind of the laser eye surgery fields.
Right.
These are just naming a few that I work on. Other clients who are in sort of 3D displays and how those operate. So it's a really wide range of different technologies, and that's just my own practice. And I mean, as a firm, we cover all different kinds of technologies.
So you don't really specialize in any one industry per se?
No, I don't. And you do find some patent practitioners do. And obviously, I say I wouldn't be able to pick up, I don't know, a case that was all about a particular fancy way of doing some particular chemistry or like metallurgy or manufacture of battery, something that's just completely outside my wheelhouse. It's got to be something that I'm familiar enough with the technology and the broader sort of landscape of that industry to be able to
so as like a patent lawyer, you actually have to understand not just the legal aspects, the legal side of things, you also have to understand your client's business. And
I think so. I think to provide good advice, you do. So to become a patent attorney in the UK and Europe, you've got to have a scientific degree background, basically.
Right.
Like, you've got to have done science or engineering. So I did a physics background. That's why a lot of my clients are in sort of a physicsy sort of engineering field.
Right.
And then you learn the law side as part of your professional qualifications. So you'll always get someone who's like scientifically competent and legally competent from any patent attorney. I think your good patent attorneys will start asking you questions about your business. Be like, well, what is the commercial reasoning behind filing this patent application? What product does this relate to? What are you actually trying to achieve here? What claim scope do you want, and why do you want that? And if they're asking you those questions, then you're going to get a better value for money out of your patent at the end and a better portfolio.
Okay. Yeah, I mean, very, very interesting. Thank you very much. And if we want to find out a little bit more about patents, about what you guys do, how you can help, how can we do that?
Well, we can go to the Carpmaels website. So I'm sure there'll be a link, but we're annoyingly spelt CARPMAELS.com. So carpmaels.com. We also have our own podcast series, which is called Carpmaels in Conversation, that's all about different aspects of patent law and particular cases and particular things that come up in particular industries. So that might be of interest as well. And then you can find me on LinkedIn and that sort of place. And those are the main places to find us.
Okay. All right. Thank you. Thank you very much. Tune in next time to Prototype and See. Whether you're working on your first product or your 10th, you've got the Prototype and See podcast to back you up through your product development journey. Follow, subscribe, and tune in for our next episode. We can't wait to see where your prototype takes you.